Hi, everyone, and welcome back. Tom Slivick. I'm with John Plasse. How you doing, John? John's,
Good morning, Tom.
Supervisor. Everybody here locally knows John's here in District 1. And, John, let's talk about, I think we have some news from the Buena Vista Casino that
we did.
Just hit maybe recently.
We did.
Fill us in?
We had a recent request from the Buena Vista Casino tribe to reopen, asking if the county would reopen negotiations for the intergovernmental services agreement.
It's called the
Let's
ISA?
stick it to ISA, yeah. But requesting that we reopen negotiations on that. Basically, the reasoning behind their request was that they have found in this difficult financial market, like we're all aware of, that it's virtually impossible for them to sell the bonds necessary to finance their casino in Buena Vista. And the business model on a smaller size casino that they were originally proposing just doesn't pencil out to be able to meet the bond indebtedness that it would take to build that. So their request was that we reopen those negotiations and consider allowing them, or the negotiations be predicated on a 1,650 slot machine casino rather than the current 950 slot machine casino.
Do they feel that would increase the footprint of the casino?
Absolutely.
Would that require another, like a ERA?
Environmental impact statement or something to that effect? It could have all kinds of ramifications, Tom, and that's part of the county's concern. We have no way of knowing what those ramifications might be.
John, when did you get this? When were you informed of this new information?
I think we got the letter about a week and a half or so ago, and we researched the terminology within the ISA agreement that is currently in place, and that terminology only allows for a stage of renegotiations of the ISA and an expansion of the casino after 1 year of operations of the current casino size.
Okay.
And that gave the county and everybody an opportunity to really assess what the impacts of a casino in that location with 950 slot machines would be, and then you could enter negotiations to further assess those impacts and know what kinds of mitigation measures you'd need to allow them to expand to a 1,650 square foot.
I guess I have two questions. I guess the first one would be: so have you guys discussed this as a board in front of people yet?
Not in public, because it came to us. It's hard to say whether it came to us in the form of came from their attorney, but in the form of actual anything to do with their lawsuit. It really didn't. It really came to us more in the form of a request to enter into these negotiations, and we discussed the matter under the guise of negotiations. We're always in negotiations with them, and those are not public hearings. And we came to the conclusion that, number one, the clauses in the ISA, the existing ISA that they were referencing, did not allow for renegotiations for an expanded casino on the basis that they've just chosen to try to make it bigger, when it only allowed for it after 1 year of operations. So we've denied the request.
To me, this kind of sounds like it's in a legal realm right now, in a lawyer.
Well,
realm.
I mean, sure. The letter from Buena Vista came from their attorney, but to our CAO. And so didn't come to our county council, wasn't really relative to that. So our CAO responded in kind from the CAO to the tribe.
For people that might not remember, I'm not sure how, the ISA agreement, I believe, came in a way like their final and last best offer kind of a way, and the county did not respond. Therefore, it became whatever they wanted it to be. I might not be saying that right, but so the terms were put, whatever terms that they had left, and then I believe it went into in the legal limbo or something.
Yeah,
the
way the process worked was the tribe and the county negotiated the terms of an ISA, and each was supposed to approve those terms. the county, in the end, the Board of Supervisors was not able to agree and approve the
Right.
agreement. So with them unable to approve it and basically reaching impasse, it went to an arbitration, and each side was supposed to submit their proposal to arbitration. The county did not submit a proposal to arbitration. The tribe did, and that is the current ISA, is what the
Oh,
tribe
okay.
submitted to arbitration.
Okay, well, I'm glad you put that in some good terms there that we can probably understand.
Try to help out.
Okay, and we're going to take a break, and we'll be back with Supervisor John Plasse after this.
You're watching Amador County's #1 news and sports leader, TSPN.
Hi, everyone, and welcome back. I think there's a few more things we can talk about here. What are some other general government challenges we've got going on here,
Well,
right here in Amador County right now?
I would say government in general is a challenge, I would say, but probably some of the more contentious things that resulted in our meeting the other day went from 8:30 in the morning till 6:30 at night, and the more contentious things, were some of these quarry expansions, either permitting or expansions of existing quarries operating in the Ione Valley area down there. So we've had some challenges from that. It almost is starting to feel like the board is always faced with having to listen to dueling experts. You know, everybody can get their expert. The proponent has their expert that says the impacts will be minimal, and the opponents have their expert that can represent or attempt to represent that there's greater fears out there that we must be concerned with, although we aren't able to identify them. And so the board sits there and listens to both sides and tries to ascertain which one has a better argument.
Bringing up right now, in a sense, like it dawned on me the other day or whatever. You know, government is actually the thing that allows the contention. Now, it's a kind of strange, but I mean, because government's the arbitrator of those ideas. You've got somebody that has the personal property, you know, the property that says, I'd like to do this, you know, and if we go back like the foundation or what, you know, of America and things like that, and you could do with what you kind of want to do with your personal property as long as you're not punching the other guy in the nose when you swing your arm, kind of a philosophy. And now to where the community says, wait, we have all this stuff at stake too. So we have new words like stakeholders and things that I've never, you know, I can't find in a constitution anywhere or anything. But I understand it. We all understand it. Government is the place where you go and get controlled.
Well, I think you made an interesting statement that government is the ultimate arbitrator of those disputes, but I think it's moved from the governing branch to the judicial branch.
Right.
Because the judicial branch has become the arbiter of these things, because in the case of the one Newman Ridge quarry, we've received that we're being sued as a result of approving that process. We received no less than 2 threats in our meeting the other day that if we didn't uphold the appeal, that it would be going to court. One by Foothill Conservancy attorney Tom Infusino, representing the opponents in that situation, and one from one of the opponents, or I guess you would call them appellants themselves. But you know, it's no longer your representatives trying to make decisions that are in the best interest of the whole and in the best interest of the constituency that elected them their representative. It's now the court system.
You've got a fine point. However, the judicial system is one of the branches of government.
It is.
And you know, we decide on that, and that's pretty good. But I get your case. Everything is then, once again, going back to dueling, if you would, experts. You know, we see this side, we see that side. And more and more here, it seems that almost everything that does want to, be accomplished by a developer or something is put in a court of law and sued on the CEQA grounds, if you would, and with people that normally, you know, wouldn't have standing. There's no damage yet, so to speak. So if I haven't hurt you, how can I, you know, and I could see the argument for that too. By the time you're hurt in an environmental way, it's
It's too late.
It might be too late. So,
and I think
very
that's the
interesting
basis.
the way things come down. So they are very complicated.
They are, and I think you touched on sort of the basis that we're left with here with the dueling experts is we as non-experts, but hopefully with a adequate dose of common sense, are able to listen to the representations of these experts on water hydrology and what might happen in the event of a flood year, a 100-year flood, and what is happening underground that both sides openly admit they don't know what's going on underground, and to accurately assess it is beyond the reality of costs. So we have to try to make our best judgment and show the concern for the concerns raised by the individuals that claim there's a possibility that they may be harmed, but at the same time try to find out what types of odds are involved there. Is there a genuine concern when one of the opponents actually says there's risks out there, we just don't know what they are? I actually wrote that quote down because for me, there's risk to everything that we don't know what they are.
Right.
But how can you possibly halt everything in fear of unknown risks?
It also seems to be, although it's based, like in a concept of rights and law, and I have mine and you have yours, they come in and they make themselves more apparent, meaning the problem makes itself more apparent with its size. If you're like myself, say if you live in a part of the county that has wells and things like that, right, and a piece of property gets sold next to you, I don't think I've never really heard of anything going on. I'm sure maybe things do, but I don't really hear of that stuff going like to a law judge to figure out whether or not my complaint of what the new neighbor might be doing when he sinks his well, I might be dried up. I don't know.
There's become this sense of ownership of everything within a sphere far greater than what your property boundary is.
But I guess what I'm saying too is that on an individual level, this doesn't seem to happen.
No, it doesn't, but I will stand here and admit to all watching that there was a proposed development adjacent to my property where I live, and I had one heck of a time getting suitable drinking water on my property. I had 3 wells and thousands of dollars and barely enough water to run a household on. So when the environmental statement for that proposed development next to me said there was a probability of contamination of groundwater, I had to say, wait a minute. Your own documentation is saying that there's a chance of this. What are you going to do to see to it that I'm not left without drinking water because you've contaminated it from your project? That's one instance. To say that our wells 2 miles away may or may not have less water production because of a relatively small size additional depth for a quarry. This quarry was permitted for 90 acres of quarry work on 90 acres, and they were proposing to deepen an area less than 2 acres 10 feet deeper than what they were currently permitted to do. So when you think of 2 acres out of 90 and you go down 10 additional feet, how can you claim that is going to impact the level of water production in wells 2 miles away, and the water will no longer flow through this aquifer? It was just hard to find that argument compelling. Okay,
and more, it's probably harder in our society, in our culture to find out where we're going, where we're headed. Okay. We enjoyed that. And I'm Tom Slivick. We'll be back with more news on the other side of the break.
You're watching Amador County's #1 news and sports leader, TSPN.